imagine what it must feel like to be Shorty, to have won at the Ninth Circuit, and then have them be like, oh, no, you didn't.
Well, and we
Hope you
see,
can afford it. Hope you
well,
can afford to litigate it.
we are the armed attorneys. Today we're talking about, all right, maybe this is the one, the case that strikes down the general prohibition on felons being in possession of firearms under 18 USC 922 G1. Now, I follow this stuff. I see how many cases and how many district courts across the country uphold convictions for this exact charge. I mean, it's in the thousands. I mean, we have New York State Rifle and Pistol Association v. Bruin. This comes up pretty frequently, and nobody seems to want to budge on it. But we have a case here that is super fascinating. The procedural history, incredible. And is this the case that makes it to the Supreme Court? Is this where we see the infringement falling? But before we begin, show your support for the Second Amendment by hitting that like button. And what is this case?
All right, well, let's talk about it. So this is the United States of America versus Duarte.
Yeah, aka Shorty.
Shorty. Go Shorty.
It's your birthday.
It's your case law. We're gonna party like it's your case law.
I was not prepared.
So what happened? He was convicted in the United States District Court of this underlying offense. And then at the Ninth Circuit, he raised a Second Amendment challenge and said, it is unconstitutional under Bruin. 922 G1 is unconstitutional. You cannot tell felons who are just felons, right? We're not making any determination on violence or dangerousness, but just the fact that you have a felony conviction, you cannot strip someone of their Second Amendment rights, because in order to even think about passing a Bruin test, you got to show that the person is dangerous.
Yeah, and we look at, all right, we have our Heller case law, we have New York State Rifle and Pistol Association, and there are some things in there, and this is, I think, what discourages a lot of folks, saying, hey, basically, these are the issues before us. We understand all these other issues live out here. All those are going to be undisturbed. We're only going to handle the thing that's in front of us. And so, we get the right to possess firearms for self-defense. We have the, right to keep and bear arms. We have, hey, this is the framework by which we judge infringements, not commenting on infringements. And we're getting to this point where, all right, the infringement litigation is starting to mount.
Yes. And so we have, right, he's convicted at trial court. We have the Ninth Circuit hearing his constitutional argument as applied. And we have a three-person panel of the Ninth Circuit. The Ninth Circuit saying, we agree with you, Mr. Duarte. This is unconstitutional. They reversed and they vacated his conviction. But then, because it is in fact the Ninth Circuit, what happened?
Well, they agreed to rehearing en banc, so that's going to be the entire court, and the guys who aren't disqualified or not recused, the whole court's going to hear this case.
Yes, which is, you couldn't just let a win sit, Ninth Circuit. You couldn't do it.
But I love it. This is, and again, this is still quite some time away, but wouldn't that be hilarious if this is the case that gets the prohibition struck down?
When they did it to themselves.
Yeah.
You did it to yourself.
I love it when they do that.
Yes. No, but it is entirely possible.
Well, it's kind of like, all right, sidebar. It's like when we saw challenges to the 18 to 20-year-olds carrying in Texas. Mm-hmm. The government dismissed their own thing because they're like, all right, we don't know what the implications are going to be outside the state, so let's go ahead and leave this thing alone.
Let's not screw with it any further. Which
is this choice. The screwing with it further?
I think that it is. But it is enraging that this happened. You know who else it enrages?
Tell me.
This one particular Ninth Circuit judge, he wrote a dissent.
Oh, yes, he did.
I have to. This is like the second video in a week in which I'm just reading a block of text, and I apologize if that offends anyone. But here's the deal. He just lets the rest of the Ninth Circuit have it because he's like, look, guys, we actually did the right thing, and you are monkeying with the manual. Right. You are mucking it up, and he is saying, he's speaking directly to the Supreme Court, and he's like, look, you can't trust us. You can't trust us. Listen to this. All right, you ready? This is from Judge Van Dyke in his dissent to the granting of en banc rehearing. He says, none of our current justices, that's in the right Supreme Court justices, none of our current justices spent time in this circuit, so perhaps it is understandable that they would reasonably expect all lower courts to faithfully imply the entirety of their Second Amendment case law. Let's be clear. Out here on the left coast, that is fantasy. The kind of subversive approach I have described will continue as long as the Supreme Court leaves an opening. Granting certiorari, vacating, and remanding, this is just any time because this has happened several times, will only serve to open up the field more for our court to contort the Supreme Court's Second Amendment guidance. The Ninth Circuit is going to joyride Rahimi. Just it goes on. I'll stop there. But
Joyride Rahimi.
But he is just letting them have it because, and this is the entirety of his dissent here is worth reading. Essentially, he's saying, look, if we as the Ninth Circuit do the right thing, we are always going to be punished for it by an en banc rehearing. We are never going to let someone's rights when it comes to the Second Amendment actually stand. And this is an outrage and an abuse. And I mean, just imagine what it must feel like to be Shorty, to have won at the Ninth Circuit and then have them be like, oh, no, you didn't.
Well, and we
hope you can afford it. Hope you can afford to litigate it.
Well, we see, all right, so the district court, I mean, he didn't raise Second Amendment issues there, but you can raise selective, most of the time.
He showed good cause for raising
good cause.
At the Ninth Circuit.
Yes, if you show good cause, he raised this constitutional issue at the appeals level. And the appeals court, they did a great job applying New York State Rifle and Pistol Association v. Bruin. They took our possession of firearms implicated by the Second Amendment. Yes, law unconstitutional, burden to government justify this law. The government didn't, and they reached the correct conclusion.
Right, because in this case, like they're basically, I mean, they go back and they're like, look, in 1791, you could engage in felonious activity, be convicted, serve a sentence for it, and immediately upon your release be handed a firearm and be instructed to rejoin the militia.
That's one of those things that I always kind of got in my craw. It's like, they're so dangerous that you let them out.
Right. And so, but that's exactly the argument that Shorty's counsel makes here is felons as a categorical group cannot, under Bruin Muster, be properly denied their Second Amendment rights. You have to show that they are dangerous. As a class of human beings, you don't just get to tell them no. You have to prove that they are someone who, under the laws as they existed in or around 1791, was denied their firearm rights because of how dangerous they were.
And unlike Rahimi, where bad facts make, I think there's some debate among scholars, but for the most part, I think we all say Rahimi didn't really do anything. When you really, there's people who say that.
I know.
I don't necessarily agree with that.
I don't. So we have people in our orbit who are like, it's like Fight Club. They're like, don't talk about Rahimi. Don't say it's Voldemort of the gun world. Like, I'll say it.
Is that nerd shit? Voldemort's? Just kidding. Like my kid doesn't make me watch Harry Potter.
Listen, I will die on the hill of Voldemort's and Star Trek every day. But personally, I'm here. I'll say it. Rahimi was wrongly decided.
I agree with you. But there was a case. I don't have the site offhand. It was out of Tennessee. It was a felon in possession case. He was convicted of was a state level misdemeanor, but it was punishable by up to 5 years incarceration. So the feds treated it like a felony. It was a window tint violation. That would have been the perfect case to go to the Supreme Court to strike down, the prohibition on felons. Mr. Shorty's case, nonviolent felony. This might be the right kind of facts for this application.
I'll take it. The Ninth Circuit's initial opinion was so good and so well reasoned, and then somehow, because we know what's going to happen at en banc rehearing, they're going to completely flippity floppity on this, and I think that I do. I think this is great. Now, we need circuit splits, not just a split within the Ninth Circuit. We need actual circuit splits, circuit by circuit. Do we have that?
Right now.
Recall. Okay.
So, all right. So what we have right now, and this may be, all right, we'll see what path this goes down. We have virtually all the circuits upholding felon in possession prohibitions, and they're all working off of their own precedents. And when their district courts are applying the laws, they're following their precedents, and talking about how these Supreme Court cases didn't change these prohibitions. And so, we do need a split. But if they, I mean, clearly they don't agree with the 3-judge panel, so we're going to have they're going to be upholding this prohibition. We need a court to break.
We do. I will say I am more confident that this is the case if in the meantime we get another circuit decision which splits.
Yes. Well, and you don't have to have
You don't have to.
You don't have to have a split for the Supreme Court to grant certiorari, but it does greatly increase the chances of it being granted.
It does. But here's the thing too. Here we go. I was all hyped up when we first started this talk, and now I'm pulling myself back down. Here's the thing too. There is going to be so much Second Amendment litigation on their radar. How much do they get to?
Right.
How much do they get to? I mean, and they wouldn't get, this is not going to hit their radar this session for certain. But, it's just going to be a matter of, I think every session, there's going to be so much 2A litigation. We're all going to be holding our breath.
Well, it's kind of like
now.
all the assault weapons bans, making air quotes. I mean, all those fell off last term.
Yep.
We had probably nearly a dozen cases left pending. I don't see this kind of flood of felon in possession cases making it to the Supreme Court in time. So, it's important. Novel issues, splits, all these things. But I think this is a case we need to watch.
It most certainly is. If for nothing else, but we all need to send out the good vibes that Shorty gets vindicated here.
Sure, but
we feel so badly for him.
We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please question and comment for us below. Until next time, we're the Arms Attorneys.